Good evening, friends. It's a real joy to have all of you here. I hope I'm audible.
Yes, you are.
Right. Okay. Thank you. It's a joy to have all of you here for this very special session. This is a session which is hosted by the Bangalore Baptist Hospital and the Companion Care India. So I'm sure that you don't need any introduction about Bangalore Baptist Hospital, a very well-known mission hospital, which is 50 years old and growing in leaps and bounds. And we're so grateful to God for that. Let me just briefly tell you about Companion Care India. Companion Care India is a non-profit organization with three important aspects, which is their main goals. One is loneliness, helping people who are lonely. The second thing is about improving the lives of people, especially when it comes to the quality of life. And third is giving access to the vulnerable group. And the CCI, or the Companion Care India, ensures this by giving physical and emotional support. And they also have a special training program called the postgraduate program in clinical chaplaincy. And apart from this, they also have counseling and also engage in training in various aspects, including in certain important key medical areas such as CPR and so on. So this evening, we are so grateful to have some very special people with us to take us through a very important topic in life, something many of us don't even like to hear sometimes, but very relevant these days. You know, I just want to say one quote by the great Mark Twain, and this is what he said: if you want to make progress, you have to get started somewhere. And I think this session is something which should spur us to this one aspect of life about making a will. So warm welcome to all of you. And it gives me great joy to introduce two people here. One is the moderator of this session, which is Dr. Spurgeon. Dr. Spurgeon is the CEO and the director of Bangalore Baptist Hospital. Dr. Spurgeon is a trained endocrinologist, and he will be moderating the session and also will begin with a very important insight into the clinical aspects or the clinical situations which come across in our day-to-day routine medical work, wherein the importance of death, will, and all that come together. So this is something which is very common in hospitals and it's important for us to know about. After that, we will have Mrs. Anuvinda Varkey. She is a lawyer by profession, and she was the former executive director of the Christian Coalition for Health. And currently, she's a partner with a consulting firm called Market and Ecosystems and is a legal wellness and a strategic consultant. Ma'am, it's a joy to have you with us. Dr. Spurgeon, it's a big joy to have you with us. I now hand over the first session to Dr. Spurgeon. After that, Mrs. Anuvinda Varkey will take over. Thank you very much.
Yeah. Thank you so much, Abby, for these kind words. I'm not taking a session, but I'll be briefly speaking, what we face as a clinician, from the hospital point of view, the challenges, especially when we are dealing with the people who are nearing the end of their life. Someone said that life consists of 6 stages. It starts with spills, where as an infant, everything will spill right from the mouth to the other end. After spills is the thrills. When you step into teenage and adolescence, life is a thrill. And then comes the bill. As you grow as a middle-aged person, you have to pay the bills. And finally, ills, pills, and the final stage, the wills. It is good for us to be aware of all these. The final event is inevitable. The probability is not even 99.9%. The probability of the terminal event is 100%. Since that is a reality, can we plan better? And it is very important. Some of the important challenges that we especially see towards the end of the life, as they continue to age, apart from the morbidity, even the mobility is also an issue. And how do we navigate healthcare? We don't have any clear sense of direction, clear, clarity about that one. And also, as people, age, mental issues are very, very common. The spectrum ranges from, delirium to dementia. It could be a reversible. Most often, Alzheimer's is an irreversible thing, dementia, where if you want to make a decision, also you will not be able to make the decision in a proper way. And also, how do we prepare for the terminal event? As a clinician, recently I met with a family. The person was admitted to the hospital and having an irreversible illness. So the few challenges that we faced, while dealing with these people. Number one, the person was diagnosed with an irreversible medical condition. Most often it is cancer. So immediately when the family knows about that one, the immediate discussion with the treating clinician will be, they want the clinician and the whole treating team to conceal the diagnosis. So the patient doesn't know what is happening, but the patient has to come every single day for some other blood test, and because the topic of death is a taboo in the Indian society. But from the clinical point of view, as a clinician, what are the challenges that we commonly face, from the patient point of view and also from the hospital point of view? When the patient is very, very sick, the question that the clinician puts to the patient and to the patient's family is about the life support, whether we need to escalate the care, putting the patient on a ventilator or not. And there are associated complications with ventilator support. And most often the reaction from the family is if they say no because the condition is an irreversible thing, but there is some sort of a guilt that is there, and there is also peer pressure from the families. Are you not putting the patient on ventilator? So there are so many things that happen. So if at all, if the person who is surviving has made a clear will, in case if some catastrophic event happens, in case if the person has to be on a ventilator, that makes the life of the family members and the treating team very, very easy. And the other important thing is when the patient is brain dead, medically speaking, the fact that the patient will not make it. It may be, 24 hours or 48 hours. And there is a huge need for the organ donation. And most often when we propose this thought before the family about the organ donation, knowing the fact that the patient is brain dead, the family will not be able to make a decision. They have multiple thoughts running their mind. But if at all, if the person, they would have made a decision beforehand, and there is a potential, to save lives of many people, giving the organs. So these are some of the things, that the clinicians face. And also it is a very huge emotional burden, especially for the patient families, the caregivers who are there. When we talk about these things, I think, before our brain drains, while the cognitive, capacity is still there. This is such a wonderful topic. I would like to appreciate Sunny, for thinking about this one, because his brain is working very, very well. He chose the right topic, and it's a relevant thing for every one of us. And I will not take much time. We have Miss Anuvinda Varkey, who has so much of experience, and she'll be taking us, and we'll be looking forward for your lecture. Thank you so much, Abby, and thank you, Miss Anuvinda Varkey, and thank you, Sunny.
Thank you.
Yeah, Mrs. Anuvinda, you can speak, ma'am.
Can you see my screen?
Yes, yes.
Okay. Good evening, everybody, and thank you very much for inviting me to speak with you today on wills and advance directives. I would like to make a disclosure right in the beginning that my slides are going to be very busy and very verbose, because I find that when I speak on Zoom, if I have everything as clearly written as possible, it's easier for people to understand what I'm saying in case you can't get if my voice doesn't come through and things like that. So once again, thank you very much for having me here this evening. The content of my presentation today is going to be on wills, on advanced directives, and maybe if there's some time, we can have some question and answers at the end of the session. I would like to start by just talking about a few definitions, which I'm going to be using throughout the presentation and get it out of the way. So what is a will? A will is a legal declaration of an intention of the testator, that is the person who's signing the will, with respect to his property, which he desires to be carried into effect after his death. A testator is a person who's making the will, and the beneficiary is the person who inherits the property under the will. So what is a valid will? Because this is a very legal document, we need to understand what a valid will is. Firstly, we need to talk about the testamentary capacity of the testator. The person who is writing the will should be of sound mind at the time of signing the will. Secondly, he or she should not be a minor. The testator should understand the contents of the will and should not be under any threat, coercion, or fraud. The next thing that we have to look at is the quality of the property. Is the property both movable and immovable? So any property, movable and immovable, can be disposed of through a will by its owner. And that's the operative word, owner. The property must be a self-acquired property of the testator, which means that you should have bought it by your self-earned property, or may have got it through a will, or may have also got it as a gift. It should not be ancestral property of the testator. If the testator is a Hindu, I'm not going to go into this whole process because it talks about a Hindu undivided family and the co-partners. I will not talk about it in this presentation. However, ancestral property for Hindus cannot be put into a will. It has to be signed by the testator in the presence of two witnesses, and that's very important. Sorry. The purpose for which we're making the will should be legal. For example, you cannot say in the will write that you would like to donate X amount of money to a terrorist organization or a drug cartel. You cannot make the will for something which is an illegal purpose. The formalities and constitution of the will, I will explain in the next few slides. Wills made by all people except Hindus, Buddhists, Sikhs, Jains, and Muslims are governed by the Indian Succession Act under 1925. However, the form of a will, as given in the Indian Succession Act, covers all except those following the Muslim faith. So these are the formalities and constitution of a will. Under the Indian Succession Act, a will should be made in writing. It should be typed or handwritten. Oral wills are not legal unless it is made by someone in the armed forces, for those practicing the Muslim faith. It should be signed by the testator. And I make a suggestion here, though this is not required, it should be signed at the end of each page by the testator, mainly because you don't want anybody to say that you have not, that people have put in other pages, or that they have managed to squeeze in some lines between this at the end of the pages. So you sign close to the end of each page where the writing ends. It should be signed by two witnesses, though two witnesses should see the testator sign the will, or the testator indicates that he has signed the will. And by signing the will, I mean either a signature or a thumb impression, whatever is appropriate at that point of time. and that the witnesses should sign the will in the presence of each other. It's very important that you have those in place. Now, before you draft a will, these are some of the things that you need to keep in mind. You need to have your photo identity in place, the Aadhaar card, passport, driving license, etc. Use the name on your Aadhaar card or your passport, whatever photo identity is there when you write up your will. Birth certificates, marriage certificates, death certificates of family members is important to have. The list of immovable properties with documents showing proof of ownership. That is very important. List of movable properties with documents to show proof of ownership. Bank accounts, stocks, shares, jewelry, etc. As far as possible, it would be good if every bank account and every stock, share, or any such document names a nominee. At this point of time, I'd like to state very clearly that a nominee is a person who's named by the testator or the person who owns these bank accounts, etc., to help get easy access to those accounts. However, a nominee is not a person who can inherit the money that is in those bank accounts or in the stocks and shares unless it is written in the will, or as if there is no will, the property will be shared as per the Indian Succession Act or the Succession Acts that applies to people from other religions. List all the liabilities and debts that you owe. List of people who you want to bequeath your properties to, along with their details, their names, as it appears in their ID proof, and their relationship with you. They may be family members, they may be friends. You need to explain the relationship. Decide on who you would like to be the executor of your will. Get their acceptance to be an executor of the will. Like to say over here that you may have one executor, you may appoint two executors in case one predeceases the other, or you may say that you want two executors to help you execute the will. If you want to form a trust through the will, speak to people you want to be trustees and get their acceptance as well. How do you draft a will? It can be on plain paper or stamped paper. Plain paper if the will is not going to be registered, or on stamped paper if the will is going to be registered. Use simple language. Avoid technical terms. It should be understood by any lay person, and it should be drafted in the first person. So, for example, I, Anuvinda, do hereby, and go on with the will. So here are some important clauses that you should have in your will. The commencement statement, where you state your name, father's name or spouse's name, your date of birth or your age, your address as shown in your Aadhaar card or proof of residence, and you may state your religion. Over here, I'd like to say that you need to have all these details in place because there may be, for example, many people who have the name Matthew, but which Matthew is signing this document? So the father, it explains that the Matthew, who's the son or the spouse of so-and-so, their date of birth or their age and the address will identify who the person is. So therefore, you need those details. State the place and date where you're executing the will. We also ask for a revocation clause to be added in the will, whether you have an earlier will or not. The reason why we encourage a revocation clause in your will is so that you can, in case anybody fraudulently gets you to sign a will or forges your will, then you can say that you revoke all other previous wills and codicils, and the one that is the latest will is going to be the will that is going to be the legal and the will that has to be executed. You need to state that you are making this will of your own volition and there is no force, for fraud, coercion on you to make this will. The appointment of executor or executors, as I've mentioned earlier, state your relationship with that person, why you're appointing them, because you trust them, etc. State that very clearly and state that they have accepted it. So please speak to the person who you would like to be the executor of your will and get their acceptance for the same. You need to have then a list of family members, people that are going to be named as significant, and other people who you may have as significant beneficiaries of your will. It is good to list all the family members, your parents, your children and their spouses, your grandchildren, whoever you're wanting to give your properties to through your will. In case you want to give money to a charity, you'd like to will a charity, do make that, put that list in as well. Please make sure that you state the debts and liabilities that you have and that need to be met out of your estate. Quite often, people do not let their families know that they have liabilities, and that comes as a shock to them when you are asked to pay up. So it's good to discuss what your liabilities are in the will and mention them very clearly and state that they need to be paid before the properties are given to bequeathed to other people. State that reasonable funeral expenses are to be met out of your estate. This is optional. You can decide how you want to do that. State clearly that the expenses to execute your will are to come out of your estate. Sometimes you need to travel. The executor may need to travel from one place to the other to make sure that all the documents are in place. Properties may be in different parts of the country. So there may be travel involved and other expenses involved, which the executor would need to execute. So make sure that you mention this clearly in the will. List the immovable and movable properties that you are bequeathing and name the person you want to have that particular piece of property to go to. Give the details of the property as it appears in the documents of the property so that there is no ambiguity on who owns it, how it is registered in the registrar's office, and what are the details of the property. That should be from the property papers that you have. Please put those details into the will. If you're leaving money in bank accounts or stocks and shares to be shared, state clearly the percentage of the amount that you want to give away and to whom. That is very important. It may not be percentages. You may just say that the monies in certain bank account will go to X and the stocks and shares will go to Y. Whatever you want to say and however you want to do it, you can then state very clearly what you want to do with each and every bank account, etc. You need to state that you comprehend and understand the contents of the will. That's a statement that you need to make in the will. State that you are signing this will in the presence of your two witnesses. Have the place and date of the signing of the will that matches the place and date as stated in the beginning of your will. Usually you state that you're signing this will on this particular date. Make sure that the dates match. Affix your signature at the end of every page, as I stated below. At the end, just before the witnesses have signed, state clearly that they have seen you sign the will and that they have signed the will in each other's presence. Give details of the witnesses, name, address, phone number, etc., and record again the date and place where the witnesses have signed the document. Registration of a will and the benefits. A will that is to be registered should be on a stamp paper. It's usually 100 rupees, but it may depend on the particular sub-registrar's office where you're going to register the will, which is within the jurisdiction of where you live. The testator and witnesses are to appear before the registering authority. This will help you prove the executor and people prove that the will was executed before the registrar, and that therefore it is a valid will. It is in the safekeeping of the registrar, and so you can always get a copy of the will later on. It gives you peace of mind, and that's why we suggest and we recommend that you register a will. However, I would like to state very clearly here, it is not a must for registering a will. Grounds in which you can be a will can be challenged, and I thought I should put this in here so that you are aware of what is how a will can be challenged. It can be challenged if it has not been signed by the testator. So quite often somebody drafts a will, the testator is ready to sign the will, and for some reason doesn't sign the will. In that case, the will can be challenged. It may be that that is the way the testator wanted it to go, but due to the lack of the testator's signature, the will not be, it can be challenged, and it is not a valid will. Lack of capacity. If it can be proved that the testator at the time of signing of the will was not in their right state of mind, and therefore signed the will without having the capacity to sign the will. There are some Supreme Court and High Court cases where they say that if you sign a will in a hospital, it can be challenged because we are not sure about, and they can try and prove that the person signing the will did not have the capacity to comprehend and sign the will. So that is another reason why it can be challenged. Lack of testamentary intention. It's very important that the testator who wants to sign the will has to have an intention to sign the will. Quite a few times, you will find children asking their parents to sign a will. They do all the procedures to sign the will, and the person does not want to sign the will. However, they sign the will. One of the parties, one of the children, one of the people who can inherit the will can say, we've challenged the will because the testator has always said he will never or she will never write a will. Undue influence or coercion on the testator to sign the will will lead to a challenge in the court. Fraud or forgery, fraudulently signed, where somebody puts a paper and say, we're asking you to sign this document without the person knowing that they're signing a will, that it can be challenged in court. And if your signature has been forged and used by somebody in a will, that on a proposed will of yours or purported will of yours, then it also can be challenged. So if certain people in the family feel that they have not been adequately compensated, they can challenge the will. But I would like to state here very clearly that because it is self-owned property, the testator can give their property or will their property to whoever they feel they want to give the property to. At times, maybe sometimes the family members have enough money and the testator feels that they would like to will all their properties to charity, they can do the same. However, that doesn't mean that it cannot be challenged in court. Overwriting on a will. If you have a will and you write something on top of it, that will be challenged and that becomes an invalid will. You can revocate an earlier will, revoke an earlier will at any time, and even any will can be revoked by stating that you are revoking the will. Here are some things that I suggest you do not put in a will. The kind of funeral that you would like to have. Discuss this with your family in advance and give it in writing in case you want, your family is not around, give it in writing to your family members in a separate document. Organ donation also is something that you should not write in a will because wills are open after the person has passed away, and not immediately after, but after a few days. And, organs need to be donated as soon as possible. So this is something that you should discuss with the family earlier and say that you would like to donate. If you've got a driving license, the driving license authorities, when you renew your licenses or you make your licenses, you can tick the box that says that you would like to donate your organs. What happens if a person does not have a will and dies intestate? This means a person dies intestate, the law applicable to the person's religion will apply. So if a person passes away, the religion that they follow, the law applicable to that will apply. So for Christians, Parsis, people who do not have any belief, the Indian Succession Act will apply. For Hindus, Sikhs, Buddhists, Jains, the Hindu Succession Act will apply. There is a separate law for Muslims, and therefore that law will apply to the Muslims. Just some things to remember. A will comes into effect only upon the death of a testator. So the will only comes into effect and can be executed only after the death of a testator. It is just a document which has no value while the testator is alive. A testator can revoke the will at any time, and a testator can add to the will by adding what we call a codicil, and the same is recognized as legal addition to the will as long as it follows the procedure of executing a will. So that is something that you need to keep in mind. Would you like me to stop here and ask if you would like to ask a few questions, or would you like me to carry on and go on to the next topic?
Thank you, Anuvinda. There are some questions which are connected to the previous session.
Okay.
So maybe shall I mention few of them now, or
maybe now because it's clear in everybody's mind, or there are you have things in your mind at the moment?
Yes. So one of the questions asked is, as a testator, how to make sure that whatever made in the will is really happening. For example, a testator is giving the assets to a particular NGO as a gift, but then the children objects it later after the death. Then what is the legal remedy, or is there a nominator? The testator should nominate a lawyer in advance to make sure the deal is happening. One question.
Okay. So as I stated earlier, it is good to have an executor of the will, and the executor of the will is supposed to follow the will as it is written. So it is the testator that puts the executor who makes sure that the property goes to the person or the charity that the person the testator has willed the property to. As I said earlier, the children can challenge the will. They can go to court and challenge the will. However, the executor then steps in and is the respondent, and they say very clearly that this is a valid will, and they have to prove this will in court. And once it is proved that it is a valid will, the court will state very clearly that the matter has to, the subject that has to, or the property that has to go to the charity will go, and the court makes an order. So you may need to go to court on this account.
Yeah, another question is that executors are a must to make a will?
Ideally, it is important to have an executor. It is somebody you trust, somebody who you know will make sure that the will be followed to the T. However, it is not a must to have an executor. But if you don't have an executor, it does end up causing some problems because who's going to take the responsibility to give away the property as per the will?
Excuse me, one question. My father has given me a property, a small property. Can I make that as a will?
Yes.
To somebody?
So it depends on your religion. If you're Christian or Parsi, it is not. It is not a ancestral property. You can give it to whoever you want. However, if you're a Hindu and the property has been divided, then your share you can give it to whoever you want. It's considered self-earned property.
No, it is given to me. I am a Christian.
You
Can
can,
I give it to anybody whom I
whoever
want?
you want to give it to. It is your self-earned property.
Okay. It is not that I bought it.
That's all right. It is considered your self-earned property. It could have been given to you as a gift. You could have inherited it as a Christian under the Indian Divorce Act, under the Indian Succession Act, which applies to Christians. It is not considered ancestral property, and it can be given to whoever you want to give it to.
Okay, thank you.
One more question, whether an unregistered will require a probate?
So there are, this is a question that's asked quite often. An unregistered will does not need a probate in most places. For example, I inherited some property in Bangalore. We did not need to go and get a probate on the will. The registrar registered the property that I inherited. So that it depends on the state that you're in. You need to check whether you need a probate or not. Probate only states that this is a valid will and it cannot be challenged. So you get an order of the court to say that this is a valid will, and therefore then it cannot be challenged and it can be executed without any problems.
Thank you. One more question is that, can a relative be the witness for a will?
Ideally, if you are a beneficiary under the will, I would suggest that you don't sign the will as a witness, because that can cause a few problems later on. However, there is no ban on you signing the will. You have to be somebody who's over the age of 21 to sign as a witness. And secondly, you are only witnessing to the fact that the person is signing the will in front of you. You do not know necessarily the contents of the will. When you are a witness to the will, you are only witnessing the fact that the person is signing the will in your presence. You are not a witness to the content of the will.
Ma'am, I have a question about assets held in joint names. For example, my husband and I jointly own the apartment that we have. So how does one list it? Does the husband, who is the first holder, list it in his will, or what happens in the event of death of one person? Does it automatically go to the survivor, or how is that situation resolved?
So if the property is in two names, it can be in two names. It is ideally, it would be good if you write a will and you will it to the other person, or you state who you want to will your share of the property to. Okay. It's up to you, because again, it's your self-earned property. You can will it to whoever you want to will it to. Ideally, it would be good if both of you decide to will it to the same person. And if, for example, one of the people predeceases the other, you can say that the will property goes to my spouse, after which it will devolve to the next. After the death of the spouse, it will devolve to whoever you want to give it to. Make sure that you give it to the same person, or say that there should be equal shares for the children, so that there's no ambiguity on the issue.
Okay, and in the case of bank accounts where there is a nominee, you mentioned earlier that the nominee is only someone who can have easy access to, and is not necessarily a legal heir to the bank balance.
Yes. So the nominee, just to say that in case you don't write a will, like an intestate will, as I talked about, the law that will apply to you if you're a Christian is the Indian Divorce Act. And under the Indian Divorce Act, we have something called, and under the other acts as well, you have different classes of heirs. First class heirs will be the immediate family. It states very clearly who are the first class heirs. If there are no first class heirs, it'll go to the second class heirs. So now if you have a bank account and you have a nominee, the nominee does not automatically get the money that is in the bank account. If in your will you want to state that the nominee gets the amount that is in that bank account, you can state it in your will. However, if you say that all the money should be consolidated and then be given to everybody, the nominee has to hand over the money to the executor, who will then distribute the money as per the will. The nominee is not somebody who inherits the money out of the account.
No, but ma'am, they always ask you for a percentage that the nominee is supposed to get. So if you put 100%, that automatically means that the bank has to give them 100% of what is in the account. Because you're signing that document.
You are signing it to them, for the bank to give it to them, but they have to give it to the executor of the will to execute it as per the will.
If it is a joint account operated either a survivor, so the survivor,
It goes to the survivor.
so in that case, the will does not, if the one of the account holders specifies that the balance in that account is to go to someone else, a third person, for example, what happens to the survivor then when the
So in the banks, they usually say either or survivor. You have taken that bank account as either or survivors, which means that both of you own the account. However, they cannot will away the whole amount. They can will away their share of the amount that is in the bank account.
Okay, so the share will be taken to be 50% or how?
It depends on how you want to write it. Usually when it's neither or survivor, you're doing a bank account with somebody you trust, and therefore it's either or survivor. But legally, if you want to will away half the amount, then you can always challenge it if they say that you want to do more than half the amount, if you can show that you had put in more of the money into the account. So that's a bit of a tricky question, and it's difficult to answer.
Thank you.
Ma'am, one question. Suppose the witness that have signed the will are no more when the will is executed, so does the stand that the witness itself are no more?
That's also difficult. But however, since the person who is the executor of the will wants to execute the will, unless it's challenged in court, if somebody challenges it and says that these people have not, they have to show that the people were not present in when the will was signed. So the onus is on the people who are challenging the will.
Ma'am, just one question, please. When the property is in a joint name, should the will also be made in a jointly or separately two wills?
You can do a joint will, but then list out all the documents, all the properties that you have, all the bank accounts that you have in the same will. Both of you should have all your documents together. So make sure that all your properties are mentioned in the will, because it causes a lot of problems later on. So then everything needs to be covered in the will where both of you are signing the will.
Okay, thank you.
Thank you, Madam. Can we just move on to the next session? Looks like that is equally important, being a living will and the advance directives to the healthcare providers.
So the legal development of the right to die with dignity under Article 21 of the Constitution. Article 21 of the Constitution gives us the fundamental right to life and a life to live with dignity. And the life may be taken away only through procedure laid down by law. This is very important that you understand this, that it can be taken away only through procedure laid down by law. There are 3 or 4 significant Supreme Court judgments that kind of helped develop the idea of, the right to die with dignity as part of right to life under Article 21 of the Constitution. So in Gyan Kaur versus State of Punjab, Supreme Court held that the right to life under Article 21 does not include the right to die. And this was a case of where somebody helped someone else commit suicide. And the Supreme Court held very clearly at that point of time that they could not, allow that. And that right to life through right to die would be a right to life under the under the Constitution, Article 21 of the Constitution. A very famous case, Aruna Shanbag versus Union of India. This is a landmark judgment. And this is where the Supreme Court held that passive euthanasia was legal. And I'll explain to you what that is. The Puttaswamy judgment, which is the judgment on privacy, interpreted the right to live with human dignity as a necessary meaning, as a right to live a dignified life until the point of death. This case where the Union of versus the Union of India, another judgment where the Supreme Court held that the right to die with dignity was part of the right to life under Article 21 of the Constitution. To enforce its judgment, the Supreme Court gave very extensive guidelines as to how an advance directive or an advance medical directive or a living will was to be executed. So active and passive euthanasia, the Supreme Court in the Common Cause case drew a distinction between active and passive euthanasia. Active euthanasia is when specific positive actions are taken to end a patient's life. For example, when a lethal substance such as an injection are administered and thereby cause the death directly, that is known as active euthanasia, and it is illegal in India. Passive euthanasia, on the other hand, is when life support mechanisms that are preserving the patient's life is withdrawn. This also is when patients are wanting to stop taking treatment and they refuse treatment. This could also be taken as passive euthanasia. But there are conditions. Passive euthanasia is when the patient's death is caused by the underlying disease itself on the withdrawal of life support measures. And passive euthanasia is legal as per the Supreme Court in the Common Causes case. The advance directive or a living will, the Supreme Court in the Common Cause case has issued guidelines regarding the advance directive of a living will, which were amended in February 2023 to simplify the procedure for the patients to execute an advance directive and the hospitals to conduct medical boards. An advance directive are documents, details the choice of the patient regarding treatment decisions. It is to be signed by the testator and two independent witnesses, not family members. Very clearly, this is not family members should sign the document before a notary public. In the Common Causes case, the Indian Society for Palliative Care, I think, filed in an application where it says that it became very difficult for people to sign a document because they had to sign it before a judicial magistrate. And it was taking a lot of time. And then the judicial magistrate had to inform the collector, and the procedure was very bureaucratic. So the Supreme Court has simplified it by saying that the document needs to be signed before a notary public. The name of the person who would be competent to take decisions on behalf of the patient when the patient is unable to take such decisions should be mentioned very clearly in the document. The Supreme Court has further amended the guidelines to simplify earlier. Each directive is to the opinion of two medical boards within the hospital itself. In the earlier decision, before the application was made, there had to be two medical boards set up, one which was set up by the chief medical officer of the district. However, now the directive is that two medical boards should be set up within the hospital itself. And there is a very clear-cut decisions on who is to be on the medical board, what are the decisions they are to take, and how can they examine the whole case. I'm not giving you the decisions on the details of that over here. The decisions of the medical boards can be challenged only in a high court through a writ petition. The current position puts the onus on the families, and it's quite bureaucratic, even though it is put before a notary public. The whole process is quite a long process. Then who can execute or who can sign such a document? It can be done by it has to be done by an adult. The person should be of sound mind. So the idea is to try and do something to execute just before you go into hospital or something like that, because then you're under pressure. It's better to make sure that you understand what the decision is. Why are you signing the document? And you need to then only sign that document. You should comprehend and communicate your decision very clearly about signing it. It should be in writing. The advance directive should be in writing. It should be voluntary without any coercion or inducement or compulsion. And it should have the full knowledge, and the person should have full knowledge and information about the illness. Components of an advance directive are similar to a will. However, I am stating the same here. The testator should name, to give its name, etc. As stated earlier. It should clearly indicate the decision relating to the circumstances in which withholding or withdrawal of medical treatment can be resorted to. So the decision should be clearly stated under what conditions you can take to withdraw or withhold treatment. The instruction should be clear and unambiguous. The testator should have understood the consequences of executing such a document. The name of the guardian or the person or the close relative who, in case the testator becomes incapable of taking the decision, will be authorized to give consent to refuse or withdraw the medical treatment consistent with the advance directive. In case there is more than one valid advance directive, the most recently signed advance directive is to be given effect. How should the document be recorded and preserved? The document should be signed by the testator before a notary public. Witnesses and the notary public should record their satisfaction on the document that the document has been executed voluntarily without any coercion or compulsion, and with the understanding of the testator of the relevant information on the illness and the consequences of the treatment or withdrawal of life support. So it's important that the witnesses and the notary public make these recordings. In the event that the treating doctor is made aware of the directive, the hospital procedure begins. 2 medical boards are constituted. The decisions of the medical boards can be appealed against in the High Court, etc. There is a very detailed procedure that has to be followed by the medical boards, and I'm not dealing with them over here. I would like to end by saying that the advance directive as envisioned by the Supreme Court is to guarantee the right to life under Article 21 includes the right to die with dignity. The Supreme Court has advised the legislator to pass a law on passive euthanasia, and the procedure laid down for hospitals to follow are extensive, and I have not covered them here, but it's important that hospitals know what the procedure is. Thank you.
Yeah. Thank you, Mrs. Anuvinda. Is there any questions in this regard from the audience? I think you can come out the slide.
Could you second last slide, the one before this, the sources? Yeah, thank you. I'll just take it.
Can you see them?
Yes, madam. Yes, ma'am. And also, madam, the slide in which that AD is first shown, like first time when it is mentioned, the Supreme Court or, yeah, this one, madam. Yes,
This one?
Yes, madam, this one.
Okay.
Madam, in this,
Yeah.
I just want to ask that this is all with respect to euthanasia, right?
Yes.
And
Yeah.
and the organ donation is a totally different thing.
Yes.
So this is known as living will, whereas organ donation is also known as living will, right?
So the Supreme Court has not necessarily stated very clearly about the organ donation. I'm sorry, I don't have enough information about that. However, I know that, when you go for an eye donation, I mean, the people who come around and get you to sign that can be taken seriously into consideration. And also when there is when you're, you go for a driving license, they ask you at that point of time, and that is taken as your will for organ donation.
Okay. Now, regarding organ this donation, I have there is a lot of ambiguity.
Yes.
Like once the person, dies, whether in hospital, home, the people immediately come, and then the family is unable to see the body because they take it out, and after that, in whatever way they stitch it back, whether the body looks deformed or it's very little. For how long this procedure takes place, and whether they stitch back the whole thing, and does it retain that original form so that the last rites could be done decently. So there is a lot of ambiguity in this regard, ma'am. Thank you.
Yeah, I agree with you over there. And I think the doctors who know more about organ donation probably can tell you about how it's done. I don't have enough information about that.
Okay.
Ma'am, I have a question.
Yes.
You mentioned earlier that the testator has to be fully aware of the illness. In the case of the advance directive, can you hear me?
Yeah, can you repeat?
You had mentioned earlier that the testator has to be aware of the illness, fully aware of the illness before, drafting an AD. What if a person is in good health but wants to, and has no specific illness, but wants to make sure that...
So if the person is in good health and wants to sign a directive, they have a right to sign it. They can say that in the event of my getting cancer or whatever the disease that they think they may get, they can then sign it accordingly. But they need to still know what are the factors, what is the effect, etc. They need to know about the illness. That's important.
So I can say, in general terms, like I do not want to be put on a ventilator, or I do not want to have my last moments in an ICU or whatever. General terms, it is allowed to do that.
You can say that, yes.
Okay. Thank you.
And what is the role of the medical board, ma'am?
So there is a procedure for the medical board. It's constituted. The directives, the guidelines state very clearly who should be the members of the medical board. The advance directive is put before them. They examine the whole procedure. They find out whether this person if in the opinion of the medical board, if the person stays on the ventilator, they will probably recover and get better. Then they will not give their assent to removal of the life support. And if the family of the members, the person who has been given the right to take decisions under the advance directive feels otherwise, then they can challenge that and go to the High Court. There needs to be 2 boards that are constituted by the hospital, and they state who the doctors are who need to be on that particular board. But it is the doctor's opinion on the medical board's decision that is final as far as the procedure happens in the hospital. If they go to the High Court has its own procedures, and then it will take a decision, and the High Court's decision will be final.
Thank you.
Thank you.
Ma'am, you spoke about having Sorry. You spoke about having two, the hospital should have two boards to certify. Now, I have a home-based primary care, and I'm not attached to a hospital. I provide home-based primary care. And I'm a primary care physician as well as a palliative physician. So when I do see patients who are on, at end of life, and could be with cancer, could be with any terminal illness. In this case as well, we need a notary to be there present when they sign a advance directive of not being taken to a hospital or not being put onto life support. How is it, ma'am?
So the thing, what happens is that when people are not in the hospital, you cannot force them to go to hospital, right?
Yes.
So,
Okay.
so they will say that we don't want to go to hospital and please don't take us, and the family doesn't take them. And they may have discussed it, but they can state it.
Daddy on Tita Gava. Sorry.
They can state it very clearly.
Okay. So it can be stated and signed without the notary as well. Just their
No,
consent.
it needs to be if you are doing an advance directive, it has to be signed before a notary public.
Even if it is at home.
Even if you don't want to go, if there is no reason for you to go to hospital, when you go to hospital, that's when everything kicks in, because then medical boards are taken into consideration, etc. You put them onto life support only in a hospital. When they're at home, you don't put them onto life support. When they decide that they don't want treatment when they're at home, they won't take treatment.
Okay, I get it. Thank you, ma'am.
Dr. Stanley, you've got your hand up.
Yeah. Yes. Thank you, Anuvinda. That is very clear. Just a couple of things, and also to answer, I think, Parneet's question.
That was me, sir.
Applies only to the hospital situation. It doesn't apply to the home, because we have been taking such decisions very often at the home situation. And so it is, but you need to document so that in case there is any, problem, you have documented, because from the law point of view, if you haven't documented, you have not done it. So you have to document everything. And there are nice documents for all these things. And the second thing I just want to emphasize is, the use is withdrawing and withholding. And this whole thing applies to that. There are guidelines for that. And in the February judgment, Supreme Court judgment, the whole procedure has been simplified because, in the ICU, you have to take decisions fairly quickly. So you have the primary doctor and maybe 2 or 3 other consultants who are involved. And Supreme Court has laid down how many years experience and all those details are there. That is the primary board. The secondary board is another doctor, senior doctor, who is not involved in this case, but also a doctor appointed by the civil authority, that is the chief medical officer. So what hospitals need to do is approach the chief medical officer and get a senior person in the admin, as the person nominated by the chief medical officer. So then it is easier. You don't have to go every time for every case to the chief medical officer. You have the document which has already designated somebody in the hospital to be that person. And in addition to that person, you have a couple of other consultants who have not been involved. And it can be from outside also, the secondary board.
Maybe a good thing to do is for the hospitals to use the guidelines and make them into SOPs for the hospitals.
Yes.
Then it's easier to, take it up.
Good evening, Dr. Stanley.
Hello.
Yeah, good evening, doctor.
Yes,
I just have a question for you.
Yes.
I have very clearly told both my children that I would never want to be on a ventilator. So don't do it. So do I have to make an AD, or if I'm taken to a hospital, can my children over there decide and say, no, my mother didn't want to be on a ventilator?
I think, Anuvinda, you'll have to answer that. But see, honor that. They cannot go against that unless it has been changed in the best interest
Okay,
of
so
the person.
I should do it.
Yeah, it's a good suggestion. In the hospital, we on a day-to-day basis facing especially patients who are in the ICU and the relatives waiting outside. This is the dilemma. It is good for each one of us to tell our dear ones, this is what I wish. This is what I do not wish. Let's talk about it at home and then bring it out so that the community can be better and family relations can be better.
Yeah.
And sometimes we feel that, we face situation where the property, the will, it's kind of a chaotic situation sometimes. So we should talk about it and, about the property and about our wish about the directives. That will make things a little more clear and easy for others. One suggestion.
Thank you. Thank you so much.
All, especially in our churches, all senior citizen groups should go through this whole procedure of making a will and making an advance directive, a living will, so that the children who are left are able to take things, peacefully and without any conflicts.
I will definitely be putting it to our church. I belong to the senior citizens group. Thank you.
Thank you. Thank you, everybody. Our time is up. Is there any urgent one question before Mrs. Anuvinda leaves us? One question, please.
Very small question.
Yes.
Can a will be made at any stage of life? For example, not necessarily when you are a senior citizen, quite in advance. For example, if an adult, can he make at any stage of life? Or is there any age limit where he has to make the will?
There's no age limit. Ideally, when you start earning property and you have stuff to give, it's good to have it very clearly written down. So ideally, that's when you should start doing it. But all of us take our times writing our wills. Lots of people are superstitious about writing wills. But it makes sure that your family knows exactly what you want to do with your property. And it's your property. You have earned it. You have every right to give it to whoever you want to give it to.
Thank you.
So thank you, everybody. And especially thank you, Ms. Anuvinda, for taking time to come forward and prepare, and as Companion Care India and Bangalore Baptist Hospital, we look forward for this kind of sessions. And in case you need any specific questions or specific help, please feel free to contact us. We already shared our email ID and a number already with you when we shared the flyer about this. We look forward for further topics till we meet next time. Thank you.